Judge Skarin, welcome to Constitutional Chats, and please tell us a little bit more about Article 3 of the U.S. Constitution.
Thank you, Kathy, and it is really good to be here with all of you, and I really am looking forward to today's conversation. So what we're going to cover just briefly, I'm going to spend about 10 minutes talking about Article 3 of the Constitution, which, if you take a look, is the section that creates the Supreme Court, and it gives Congress the discretion to establish lower courts. What's interesting about Article 3 is that you'll see that if you go and read it, it is very short. Unlike Article 1 with the legislature, Article 2 with the executive, there's a handful of things that are enumerated there. So let's just walk first through the basics of what Article 3 actually says. Obviously, it creates the Supreme Court and gives Congress discretion to establish lower courts. Article 3, Section 1 also gives judges life tenure. In other words, it says that unless judges are impeached, once a federal judge is on the bench, that judge stays there for life. And then the second thing that it does is it says judicial salaries cannot be diminished. In other words, once a judge is a judge, Congress can't come along and pass a law and say you earn less money now. Those are both interesting because those protections are directly traceable to disputes that happened in colonial America in the 1760s regarding judicial independence. And if you read the Declaration of Independence, what you'll see is that there's an express mention of those problems as grievances against King George III as reasons why the American Revolution happened. The clause there is that George III made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. So that's the first thing that gets addressed in Article 3 is judicial independence to make sure that judges can do their job without worrying about the executive trying to undermine them as George III was accused of doing. Section 2 of Article 3 lays out the types of cases and controversies that the federal judiciary can hear. And what's important to note here is, like with Article 1, like with Article 2, Article 3 sets out a limited form of government with regard to the judiciary. If there's not a category of cases or controversies listed, then the presumption is that lawsuit needs to happen in state court. And the types of categories are listed there in Section 2. Some of the bigger categories are, first of all, federal question jurisdiction. In other words, is there a lawsuit alleging that somebody violated a federal law or violated the federal constitution that gives them a claim? You also have categories for things like cases between states, cases where the United States itself is a party, cases between citizens of different states. And then there are some categories for some less used categories, things like my personal favorite, admiralty, which is cases involving ships and pirates and the high seas and things like that, and then some other smaller categories. And then if you go to Section 3, it lays out some specific rules for cases involving treason against the United States. And when you get through that section, that's Article 3. That is an overview of what it says. Article 3 is extremely short, and our takeaways from the text of the Constitution itself is the Supreme Court's the only court that is required to be created. Congress has the discretion to structure the rest of the judiciary as it believes appropriate. And you need a specific reason to be in federal court. Otherwise, your lawsuit is going to be brought in state court. So once I say that, there are some obvious questions that should be coming to mind. And the first question is, well, where does it say that the Supreme Court or the other federal courts decide whether a law is constitutional or not? In other words, where's the concept of judicial review? And you can read Article 3. You could probably read it in less time than it takes to tell about it. You won't find judicial review in Article 3 as an explicit concept. There's nothing that says the federal courts shall decide if a law Congress has made violates the Constitution. So where does that concept come from? Where do we get what is really one of the central elements of our judiciary as it functions today and has functioned throughout history? You can see that concept starting to percolate if you go and you look at the debate about the ratification of the Constitution. One of the concerns stated by opponents of the Constitution is that, well, you've created a judiciary, they will have the ability to decide if laws conflict with the Constitution, and therefore the judiciary must be superior to the legislature. And that's a concern that has a lot of weight at the time the Constitution is ratified, because in the colonial period and during the Revolution and shortly thereafter, legislatures were cherished as a guard against tyranny, particularly against royal tyranny. And so Federalist 78 in the Federalist Papers, Alexander Hamilton takes that issue and that concern head on. And he makes an argument that really boils down to starting with the proposition that the Constitution is superior to any contrary laws the legislature might pass. And then he moves to the argument that judges, based on their role, their job, have to decide what law to apply, and that the Constitution as a fundamental law, or the fundamental law, means that the judiciary has to decide what to do if there's a variance between a law passed by Congress and the Constitution. And Hamilton says, quote, "The Constitution ought to be preferred to the statute, and the intention of the people to the intention of their agents." In other words, the Constitution represents the will of the people. Statutes passed by Congress represent the will of the agents of the people, and therefore have to be in conformity with the Constitution. So his move is to say, not that the judiciary or the legislature is superior. His move is to say the Constitution is superior, and judges of necessity, when they're deciding cases and controversies, must decide whether the Constitution can coexist with a law. So that's the argument that's made at the time of the ratification of the Constitution. But that principle is really still, maybe one way to put it is a little bit uncomfortable in terms of whether or not the judiciary is actually going to be able to exercise that power and how they will do that. And that issue comes to a head in a case, very famous case called Marbury versus Madison from 1803. And you need the facts briefly to understand what's going on there. At the end of his term as president, John Adams appoints a number of federal judges. And he, among the individuals who are appointed, he appoints William Marbury to be a justice of the peace in Washington, D.C. Adams signs the commission. Marbury is supposed to be a justice of the peace, but as Adams is leaving office, the mail doesn't get delivered to Marbury. He never gets his commission. So Marbury brings a lawsuit against the Secretary of State, James Madison, saying, "Give me my commission, let me be a justice of the peace." And this lawsuit goes to the Supreme Court and puts Chief Justice John Marshall in a really tricky spot, because Thomas Jefferson is now the president of the United States. And if Chief Justice Marshall orders the commission delivered to Marbury, Jefferson very well may just ignore that order. And if he does that, it would establish a precedent of the president ignoring decisions made by the Supreme Court, and thereby really undermine the entire branch of government in the judiciary. So the Chief Justice goes through a number of points in his argument, and he starts with the proposition that Marbury absolutely has a right to his office. He has a right to be a justice of the peace. The commission signed. There's nothing else that needs to happen for him to be the justice of the peace. And he points out that if you've got a right like that in a country of laws like the United States, you can vindicate that right with a lawsuit in a court. But then the question that Marshall asks is, but even if there is a right, does the court where you brought the lawsuit have the power to give the remedy that you're asking for? And remember the remedy that Marbury has asked for. He's asked for an order telling Madison, "Give me my commission." And the legal term for that is a mandamus. And what's important is Congress, when it was setting up the court system, as I mentioned at the outset, it had written a law that says the Supreme Court may issue writs of mandamus to federal officers. In other words, Congress passed a law saying, Supreme Court, you can absolutely give Marbury exactly what he's asking for in order to James Madison to get his commission. And what Marshall says is, however, wait, we have to pause for a second. Article 3, Section 2 of the Constitution sets out the types of cases that the Supreme Court can hear. And importantly, it says that the Supreme Court has what's called original jurisdiction as to only a handful of types of cases. In other words, as opposed to appellate jurisdiction. Original jurisdiction is the lawsuit starts here. Appellate jurisdiction is the lawsuit starts somewhere else, and then you bring an appeal to the Supreme Court saying something went wrong, please fix it. John Marshall rather points out that a demand for a commission is really, it's an original case. You are saying, Supreme Court, order Madison to give me my commission. So the statute, what Marshall says is, you don't have a provision in Article 3, Section 2 that allows you to bring a lawsuit against a federal officer for mandamus in the Supreme Court. Therefore, we have a conflict between the Constitution and the statute that Congress passed that says you absolutely can bring that lawsuit and ask for that order. Marshall then points out Congress cannot by law change the Constitution because, again, the Constitution is the fundamental law of government in the United States. And in echoes that should sound familiar from Federalist 78, courts have to decide what the law is in order to decide cases. And that means that courts have to decide what law is superior. And here, that law is the Constitution. And the famous passage that you'll hear people quote, and that the Supreme Court still quotes to this day, Marshall states, quote, "It is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each." And therefore, what Marshall's conclusion is, Marbury has a right to the commission, but the Supreme Court can't give him that commission because the Constitution doesn't allow the Supreme Court to order that commission to be given to him in the first instance, and that's regardless of whatever Congress said to the contrary. So what Marshall has done is he's taken his tricky position where he's worried about what Jefferson might do if he makes an order, and he's put President Jefferson in a tricky spot instead, because what John Marshall just said is that the Supreme Court gets to decide if laws are constitutional or not, which is something that Jefferson very much is concerned about. But Jefferson can't really complain because his side just won the case. And what is, from your perspective, either hilariously funny or really tragic, is history tells us that Marbury never does become a justice of the peace. He never does get his commission. And as a result, what happens is Marbury versus Madison comes to be cited as the case that really establishes judicial review. And so that's the story of where judicial review came from and how we got there, in spite of Article 3 not stating it explicitly. So that's kind of an overview of Article 3 and what it says. More importantly, what Article 3 does not say, and then how judicial review came to be what it is today, or at least how it got started in the early years of the American Republic. So that's an overview. And with that, I think, Kathy, do I throw it back to you for questions?
Yeah, and I have to say that was one of the best summaries and explanations of Marbury versus Madison I've ever heard. So thank you for that.
That's nice of you to say. It's a little bit messy if you go and actually read it.
Yeah, I've always found it really complicated when I've tried to read it. You really laid it out very well. And before I toss it to Tova, I just wanted to ask if you could just clarify on the original jurisdiction and the appellate jurisdiction. Could you, and you may have said this and I just may have missed it, but could you explain what is the original jurisdiction of the Supreme Court? What are the types of cases that don't have to come to it by appeal?
So that's actually a question that has some nuances to it. But if you go and look, original jurisdiction just means the lawsuit starts in the Supreme Court. And so, for example, if you look at Article 3, Section 2, you'll see that cases involving ambassadors, cases with states as parties, technically those start in the Supreme Court. So even today, if you look where it typically will come up today, is you may have cases involving things like water rights out west. There have been some Supreme Court cases in recent years where one state is suing another state saying the river is upstream in your state, you're taking too much water out of the river, and as a result, not enough water is coming down to our state and our river is running dry. Those cases technically start in the Supreme Court. Now, what the Supreme Court usually does is it delegates a lot of the fact finding down to a different entity, as a practical matter, get the work done today, but that's an example of original jurisdiction. And then other cases with regard to appellate jurisdiction, that just means you start the case somewhere else. In today, it would be typically in a federal district court, though not always. And then if there's a problem in terms of you thinking that there was an error of law made, you can appeal to the Court of Appeals, and then ultimately you could ask the Supreme Court to take your case on a writ of certiorari if you believe that there is an issue that is important enough that the Supreme Court should address that issue. There have been, over the years, there have been a number of statutes passed by Congress tweaking what cases must start at the Supreme Court and what cases do not. And the details of that get complicated and very messy very quickly, but that's at least a quick overview of that issue.
That's great. Thank you. Well, I'm going to turn it over to Tova.
Well, great. Thank you so much. I fully agree with Kathy. That was a great summary. I feel so bad for Marbury, but at least his name is in history now. So I was wondering if you could discuss a little more about the English system of courts and sort of what the founding fathers based this article on. Where did their ideas come from? What were they trying to model off of?
Okay, so there's a lot of different pieces there, and I'll just say that I can't claim to be an expert on the English judiciary. What I can tell you is that historically, going back into the 1700s and the 1600s and the 1500s, the judiciary was originally considered part of the executive branch. And if you were to go over to England in that time period, it's changing by about 1707. There's an important judiciary act that is passed by Parliament in 1707 with regard to the English courts. But historically, judges were viewed as agents directly of the king and directly of the crown. And what is developing in both the colonies and in Great Britain in the 1700s is the notion of courts as separate and apart from the executive. And my understanding of that history is that change is actually happening more quickly in England, or in Great Britain rather, than it is happening in the colonies. So if you look at the colonial systems of the judiciary, what you will find is that the judges, in many instances, just varying by colony, will be members of what is called the Governor's Council. So the colonies had a governor appointed by the King of England, and then they also had, typically appointed by the King of England, a dozen counselors who were a lot like the governor's cabinet, but in some instances, they would also be the upper house of the state legislature or the colonial legislature, and they would also often be the Supreme Court judges of the colony, along with the governor, who would also, in many instances, just depending on colony, sit as a member of the Supreme Court. So you have this merging of roles in the executive branch in the colonies. And what is developing both in the colonies and in Great Britain over that 1700s rough time period is the notion that we're going to have judges as separate and apart from the executive. So I don't know if that answers your question, but it's very much a time where the judiciary and its existence and its responsibilities are in flux, which is why you have questions like Marbury versus Madison coming up in terms of what is the relationship of the judiciary vis-a-vis the other branches of government.
Well, that's fascinating. Thank you so much. That was a great overview. And then sort of switching gears a bit, I know in Illinois right now, there's some Illinois Supreme Court seats up for election, and it's, pretty competitive election. So I was curious why some states or a lot of states have elected judges, whereas the Supreme Court is kept, appointed by the president and confirmed by the legislature. Why is there that difference?
Well, and the first thing that I just have to say is I'm not running for office at this point, which then by our judicial code of conduct precludes me from taking a position as to any specific candidate for election. That said, you are right. We do have 2 of the 7 seats on the Illinois Supreme Court up for election in November. And I suppose one answer to that question might be go look up the podcast from back in November when we talked about, when I was here and we talked about state courts and their role in our federal system. But the short version is the states have the authority in their state constitutions to decide how they wish to structure their judiciaries. And so many states have chosen to have different forms or different methods of deciding who their judges and their justices, both at trial and appellate and Supreme Court levels, they wish to have. And in Illinois, excuse me, that method is election. The founders, and you can go and read really Federalist 78 is a good source of some of the thinking for why things like life tenure were granted to the federal judiciary. But the short answer is the federal courts have life tenure and are nominated by the president and confirmed by the Senate, because that's how the founders decided to set up the system, in large part because of those concerns that I mentioned at the outset about George III and some of the ways that the colonists believed he had undermined judicial independence. And as a result, it was very important to the drafters of the Constitution to ensure that federal judges and federal Supreme Court justices had the ability to make decisions without worrying about the political consequences of their decisions, or without worrying about whether they would lose their jobs as a result. That's the balance that they chose to strike. And you can look at examples from the states, the laboratories of democracy, as to, for examples of how less judicial independence can impact the actions of the judiciary. That's probably well beyond the scope, other than to just note that you can look at those distinctions and make your own decision as to whether the founders were correct or not in terms of how they structured Article 3, Section 1.
Thank you. And then I know there's been some controversy over the number of Supreme Court justices and whether to expand, whether not to. And as we've seen, the number of Supreme Court justices isn't set in this article. So, what was the number it was originally set at? How did it expand to its previous number? Could you give an overview of that?
Sure. And I'm not going to take a position as to whether or not the number of Supreme Court justices should be changed. Tova, you're exactly right that Article 3, Section 1 doesn't say how many Supreme Court justices there must be, and it is left to Congress to make that decision. As a practical matter, in 1789, Congress passed the Judiciary Act of 1789 that set up the court systems, at least initially. At that time, there was a Chief Justice and 5 Associate Justices, so a total of 6 justices. There have been some minor changes in the number of justices in the 1800s. From 1837 until 1863, there were 9 justices. From 1863 to 1865, there were actually 10 justices. That's the most justices there have ever been. And then from 1869 on to the present, there have always been 9 justices. So the most justices there have ever been on the Supreme Court is 10 for that brief period of about 2-3 years during the Civil War. And then other than that, 9 has been the number of justices for the overwhelming majority of US history chronologically. What I would probably do as just a final comment about whether or not the number of justices should be changed, Justice Breyer, who just retired at the end of the Supreme Court's term, wrote it was really a lecture that then turned into a short book titled The Authority of the Court and the Peril of Politics. And his comment on this specific question was that the court's authority and here's the quote, like the rule of law depends on trust, a trust that the court is guided by legal principle, not politics, structural alteration of the court motivated by the perception of political influence can only feed that same perception, further eroding the public's trust. So that was Justice Breyer's perspective. He obviously has been on the Supreme Court for many years at this point, and I'll probably just let him have the last word on that question.
Sounds like a plan. And then I wanted to talk a little bit about the idea of precedent. If you could discuss that a bit. What is the idea of precedent? How, to what extent are Supreme Court justices supposed to follow it? And how do you decide whether to rule on precedent versus whether it follows the Constitution? Could you give an overview of that?
So another way of referring to precedent is stare decisis. So you'll sometimes hear it referred to in that regard. And what most people don't realize about precedent or stare decisis, or however you term it, is there's really two types of precedent depending on what court you're talking about. So where I sit, I am in a trial court of general jurisdiction. So what that means is that my job is to apply the cases of the courts that are above me, my Illinois Intermediate Appellate Court, my Illinois Supreme Court, and then above that, the U.S. Supreme Court, to the best of my ability. So if I have a appellate court decision, or if I have a state Supreme Court decision, or a federal U.S. Supreme Court decision, my job is not to say, I think that's wrong, let's do something else. My job is to say, I follow what the appellate courts have, or the Supreme Court has interpreted in, and apply it to the facts of the case the best I can. In terms of the Supreme Court and the Supreme Court's role in addressing precedent, that's really a decision for the 9 members of the Supreme Court as to their views on precedent and stare decisis and how it should apply. And you can go and read their different perspectives on precedent and how it should apply. I'm drawing a blank on the name of the case. You might look at, I believe it's the Gilbert case from maybe 2 years ago. Clarence Thomas wrote an extensive discussion of stare decisis and its role. And that would be one place that you could go to look at that view. But the fight is essentially one of disagreement among the justices as to the extent to which you say the text of the Constitution and its meaning at the time that it was enacted is something that the Supreme Court is to give meaning to. And therefore, in the event that Supreme Court precedent conflicts with that meaning, the Supreme Court has a duty to change that to bring it into conformity with the text of the Constitution, versus other concerns such as concern for the institution of the court changing its mind, concerns about people who have made decisions in reliance upon prior Supreme Court decisions that have been made, and in terms of other considerations that, again, you'll see laid out in the cases where these arguments are taking place. And as to that debate and what the correct view of precedent is at the Supreme Court level, I'll probably just note that that is the nature of the dispute. As to who has the best of the argument, it really is incumbent upon citizens of the United States to take a look at the arguments that are made and draw their own conclusions as to who has the better of the argument.
Well, thank you very much for answering all my questions and for being on the show. I'll pass on, to the next person.
Hello, and thank you so far for everything that you've talked about on the show. So my first question is, I think it's pretty interesting that the Constitution does not give an exact structure to how the courts are to be set up, and it gives that power to Congress to set up that court. And now we have district court and leading to the Supreme Court, but that was not in the Constitution itself. So Could you just comment on that a little bit more first, and then I'll ask another question or two?
Sure. So that is the decision that obviously was made in the Constitution, and Congress had, what's interesting is Congress has made some very significant and important changes in how they've structured the court, but we more or less, since, depending on how you look at it, the late 1800s, had the exact structure that we have today, which is you have federal district courts where you have juries, you have witnesses, you're deciding what happened. You're deciding what the facts are. And this is, if you think of, movies like My Cousin Vinny or TV shows like The Good Wife or LA Law, those are the trial courts, the federal district courts. And the goal there is decide what the facts are, decide what happened, and then apply the law to it. Above that, you have the federal circuit courts. And that is, their job is to fix any legal mistakes that might be made at the trial court, whether it is the trial court just got the law wrong, or whether the trial court let evidence into the record to be considered by a jury that shouldn't have been allowed in, or whatever the legal error might be. And then above that, you have the Supreme Court, and their job is to essentially settle disagreements between different courts of appeals on legal issues. And so they don't take every case, they take very few cases, and they're deciding, is this case an important one? Typically, not always, but typically, because the courts of appeals are getting different results as to what the law should be. And therefore, if you bring your case in, say, the Ninth Circuit, which is out on the West Coast, you're going to get a different answer than if you have your case in the Seventh Circuit, where I am. So that's at least the structure that Congress has chosen to set up. And that structure, while it has been entirely consistent since the very late 1800s, early 1900s, we had, with some distinctions that are probably more detailed than we need to go into, a somewhat similar structure throughout American history, starting with the Judiciary Act of 1789.
If judicial review had not become enshrined, what was the other, then what would the function of the court be without having judicial review, I guess?
It's actually a really good question, and probably the easiest answer is, I don't think that there's any way to know. You would have, and you have hints of this even after Marbury versus Madison. There's the famous example of President Jackson in the 1830s essentially disregarding a decision of the Supreme Court with which he disagreed. And that goes back probably to what you would in all likelihood have had is you would have had more of that, more instances where the Supreme Court in many cases would have resolved the case and everybody would have accepted the decision and would have moved along. But in a handful of cases, and perhaps especially in cases where there was conflict directly with either the executive or the legislature, it's entirely possible that people would have just ignored the Supreme Court's decisions. If you look at Federalist 78, one of the other things that Hamilton points out there in his passage where he talks about the judiciary being the least dangerous branch of the three branches of government, he goes on to kind of explain why he says that. And Hamilton at various points in history has either been lauded or criticized for his comment that the judiciary is the least dangerous branch, but he explains exactly why and what he is saying in that regard, because he points out that the executive, which is Article 2, holds the sword of the community, and he points out that the legislature, Article 1, commands the purse and prescribes the rules for the country, and he contrasts the judiciary as not having those powers. So what does that really mean when you contrast it with the judiciary? When the executive holds the sword, that means that even today, when a judge orders something to happen or decides a case, there's no judicial staff that makes sure that it happens and punishes anyone who disobeys. There's no judicial judicial police force or judicial bureaucracy to ensure compliance. And with regard to the legislature holding the purse, the interesting thing is, even today, even though judicial salaries cannot be diminished, every year the federal court system literally has to go to Congress and say, here's our budget, please fund the court system. And also, Congress obviously has the authority to pass new laws if they believe it's proper. And you can look at examples of that where Congress has passed a statute and the court has interpreted that statute. Now, we're not talking about judicial review in terms of deciding whether a statute is unconstitutional or not. We're just saying that the courts obviously have to interpret statutes in order to resolve cases, even if there's no constitutional question involved. And from time to time, the Supreme Court will make a decision saying, here's what we think the law that Congress passed means. And Congress will come back and say, we disagree, we're going to pass a different law instead. And they're entirely allowed to do that, and that is entirely constitutionally proper. One example would be maybe in 2000, there was a case called FDA versus Brown and Williamson Tobacco Company, and the details don't particularly matter for our purposes, other than to say the Supreme Court said, as a matter of statute, that the Food and Drug Administration lacked authority to regulate tobacco products. And in 2009, Congress came back and passed a statute that explicitly said, no, we disagree. We're going to give the FDA the explicit power to regulate tobacco in response to that 2000 decision. And as a result, that's FDA versus Brown and Williamson, at least its central holding, is no longer good law as a result. So those are some different examples, both starting with your question of what might have happened if Marbury versus Madison came out differently, as well as then just some discussion really from Federalist 78, but then throughout history of some of the inherent weaknesses that the court and the Article III judiciary has vis-a-vis the other branches.
Yeah, and I think that we often see large decisions which impact our life or get a lot of notoriety, and there's big news stories about them, and we don't always go to that next step of thinking, well, the court can't do this alone. And also, as a comment, we talk about almost legislative rulings where, like, the Supreme Court may legislate from the bench. But I've almost had the opinion where I feel like the presidents and Congress have almost used the Supreme Court in certain ways to do things that maybe have been less popular for them to do themselves, and possibly should have had an actual bill passed, like the situation you just said, where Supreme Court ruled and then Congress came back and actually passed a law giving that power explicitly. Seems more or less of how the country is more set up to act, that Congress is acting proactively, doing things, and the judicial system is pulling backwards in a sense, or conserving. Maybe you could comment on that as my last thing, and then we're going to have to get to the audience questions.
Well, I think what you're maybe getting at is something that is mentioned in Article 3, Section 2, where the types of cases and controversies that the court decides are laid out. The judiciary is by nature reactive. In other words, the judiciary does not decide a case unless somebody believes that they have a grievance of some sort and brings that case saying, here's what I think the law is, here's what I think the facts are, please give me relief. So the way that the founders set up the system is the legislature is obviously very much not like that, in that they have the ability to proactively say, we think that the country needs a law on this particular topic, whatever it may be, and they have the ability to hold hearings to develop information in terms of what might be a good or a bad idea in terms of what legislation should look like. And then obviously they have the ability, either in committee or on the floor of the legislature, to debate the language of a particular statute and pass it. And that statute obviously gets applied to all individuals to whom it applies, as opposed to what the courts do by definition is decide a dispute between particular individuals. Now, in deciding a dispute between particular individuals, a court very well may need to make a determination that would sweep more broadly, for instance, interpreting what a statute means. And then you go back to the discussion that Tova asked about with regard to the nature of precedent, but you're correct in highlighting the distinction in the types of decision-making between the judiciary and specifically the legislature.
Yeah, and I think that in a way, obviously it takes a long time for something to get to the Supreme Court often, but in a way it can have a more sudden and sweeping effect when that ruling comes out. Even, I mean, if you think about the most controversial bills that have been passed versus the most controversial Supreme Court rulings maybe in the past decade, and of course there's been both, but I'm trying not to just name a bunch of controversial things on the show right now.
We'll stay away from that, right?
Yeah, but it definitely seems like there's been political agency that has seen it as effective to send certain things through the court in order to achieve political outcomes that could have also just instead have been accomplished by a bill being passed, but a bill wouldn't have gotten passed.
Yeah, I don't know, and that's obviously going to be very, very fact specific on a particular time. Beyond that, I'm not sure how to. Do we need to go to audience questions, or where do we go from here?
Yeah, we can definitely go to audience questions. And thank you so much, Judge Skarin. It's just been really fascinating. Now, Linda from Texas asks about the Articles of Confederation. She asks, is it true that in the Articles of Confederation, there were not 3 branches and Congress had the powers that the judiciary branch has now?
You know what? I would need to go back and read my Articles of Confederation. So I will fall on my sword and just say that I am not sufficiently up to speed on exactly the structure of the Articles of Confederation during the, the interim from essentially during the Revolutionary War up to the ratification of the Constitution. So I guess that's a pass, other than to say it's laid out in the articles. I know that, I just don't have all of those pieces directly at my fingertips today.
Yeah, no, that's fine. And then Connor from Ohio asks, how do you become a clerk to a U.S. Supreme Court justice, and what is it like? What do you do?
I always joke that you get hit by lightning and are very fortunate. So that's the short answer. The mechanical steps as to how do you get to that job are, obviously you need to go to law school, and typically you will need to go to a very good law school and do very well in law school. And once you do that, then at least since prior to about 1975, occasionally people would be hired directly out of law school to go work for a Supreme Court justice. That certainly was not always the case. Even by 1975, it was pretty unusual. But ever since that time, people coming out of law school will go clerk for a federal judge, typically a federal court of appeals judge, which is what I did. And like in any profession, there are some court of appeals judges who particularly stand out as well-known, well-respected jurists. And those judges tend to have law clerks who then will subsequently apply for and be hired by Supreme Court justices. And so my path is, I went to Northwestern. I did very well there. I clerked for J. Harvey Wilkinson III on the Fourth Circuit. The Fourth Circuit Court of Appeals is the federal court for Maryland, West Virginia, North and South Carolina. So any trials that happen in those states in the federal courts come up to the Court of Appeals for the Fourth Circuit. Judge Wilkinson was and is a very well-respected Court of Appeals judge. After that, I applied and had an interview with Justice Thomas, and eventually was fortunate enough to get that job. In terms of the second part of the question, which is what do you do once you get there? I think most people don't realize that there is not any permanent legal staff of the federal courts, whether it's federal district court, Court of Appeals, or Supreme Court. So most judges have 3 or 4 law clerks, and between the law clerks and the justice, they do all of the substantive legal work. So you're helping the judge or the justice to prepare for cases. You're helping the judge or justice to write decisions, and you're doing whatever. You're essentially, I call it being like a peripheral brain for the judge or the justice, to help them get their work done. And so that's the nature of it. And when you are writing, for instance, writing an opinion, you typically will go back and forth a number of times with the judge or justice for whom you are working to make sure that that decision is exactly what the judge wants the decision to be. So there are no judicial decisions that I've worked on that are my decision. They're all Judge Wilkinson's decisions or Justice Thomas's decisions. But there are some decisions where I helped to write those decisions and then helped to edit it to get it exactly the way that my judge or my justice wanted the decision to read.
Well, it sounds like a great experience, and thank you for taking the time to explain that. We may have inspired some future Supreme Court justice law clerks today.
If you have the chance to clerk at any level of the federal judiciary, you should absolutely very seriously consider it, because it is one of the most interesting and enjoyable jobs that you can have as a young, recent law graduate. And it is also tends to be a very rewarding experience in terms of the relationship that you develop with your judge or your justice. These are people that you will enjoy talking to really for the rest of your career, and many judges view it in that way as really a mentoring role that they should have, and it's something that is very special.
Thank you. Now, Martha Jenkins says, this isn't a question but a comment. A really good book on the history of the Supreme Court is Saving Nine by Senator Mike Lee of Utah. So we just thank you, Martha, for that suggestion. And then Carolyn from Virginia asks, what is the biggest challenge, in your opinion, facing the judicial branch today?
The biggest challenge. I think that maybe one of the large challenges, I'm not sure it's the biggest, but there seems to be a strong tendency of people to simply decide whether they like an outcome from the court versus doing the hard work to really understand why a court did what they did. So the interesting thing is, any court, whether it's a trial court or the Supreme Court and anything in between, will explain precisely why they came to the conclusion that they came to. And if you are reading a quick 90-second news article, or even worse, if you are getting your news on Twitter, you're going to understand what the outcome was, but you will have utterly no understanding as to why the court, whatever court it is, explained the reason for what it did. So I would say that is a problem that our citizenry faces. And the good news is there's an easy solution. The easy solution is take half an hour, take an hour, go to whatever court's website has made that decision. All of the decisions are published. All of the decisions are available. You don't need any subscription service to get copies. For instance, if you want to know what the Supreme Court thought about something, go to supremecourt.gov and find the decision and read it, and then decide if you think that one side or the other side made a more persuasive legal argument. Everyone thinks that this is esoteric or hard to understand. Sometimes it is, but typically a well-educated individual with a decent reading comprehension, which I imagine is pretty much everybody who is listening to the podcast, can read and work through and understand why a court did what they did. Go do the hard work. That's the challenge that we have as citizens, maybe more broadly, but it's certainly a problem that the judiciary faces. Is it's very easy to decide if you like an outcome. It takes a little bit of effort to understand why the outcome happened, and it takes a little bit more effort to understand and decide who you think got it right. So I would just encourage everybody to take that step as informed citizens and people who want to understand why the judiciary does what it does.
Well, that's so true. And one of our favorite quotes here at Constituting America is John Adams: "Liberty cannot be preserved without a general knowledge among the people." And so that's what we're trying to do is educate ourselves and have our audience join us in learning more each week. And so we thank you so much for your time today. And we thank everyone in our audience for being with us. And earlier I had read the names of some of our great donors who were on. And as I looked through the audience, I saw so many more that I just want to recognize Diane McKee, who actually became a monthly contributor during our show. So thank you, Diane. And Jim Morris, and I think I had said Philip Kamen earlier, and Bob DeMartino, and Nan Nickel, and Peggy Forrester, and Patricia McGann, and Whitney Mason, and I'd mentioned Martha Jenkins earlier, and Don Hay, and Sharon Tates, and our senior essay winner, Lawson Barclay, was on with us too. And if you are senior, and I hate to say it, we define senior citizen as over 55 for our contest, and I'm 60, and I don't really think that. I still feel pretty young, but if you're over 55, enter the senior essay category like Lawson did, and maybe you'll win that. So just want to thank you again, Judge Skarin, for your time and all your wisdom. And Tova, Jewel, any closing comments?
Yeah, thank you so much, Judge, for being on. We really appreciate your time and your expertise. And to everyone watching, thank you for joining us as always and being part of the Constituting America family. And please consider donating, as Kathy said, because the programs Constituting America runs are truly life-changing. So have a great week.
Thanks for being here, and another great show. And everyone out there, come back next week and tell your friends.
Definitely. And next week, we're going to talk about the size of the Supreme Court. So we talked a little bit more about some of those issues we raised earlier. And we also invite you to join us this Thursday evening with Gordon Lloyd. We're talking about his book, Debates in the Federal Convention by James Madison, a member. It's going to be a great show, Thursday, August 11th, 7 p.m. Eastern. So thank y'all.